Good afternoon. My name is David Grothus. I have a speech I'd like to share with you today. The title of my speech is January 6, 2021, a defense of January 6 detainees. Number one, entrapment by the United States government of America. Entrapment by the United States government of United States citizens. Number one, individuals directly involved. A, Nancy Pelosi. B, Ray Epps. C, Capitol Police. D, FBI agents. Number one, subpoena both Nancy Pelosi and Ray Epps to answer questions to be cross-examined. Request documents from Nancy Pelosi and Ray Epps' phone records 1 month before and after January 6. Request bank transactions of both Nancy Pelosi and Ray Epps 1 month before and after January 6 of 2021. Subpoena the top 5 Capitol Police employees to be cross-examined. Request documents of phone records of each Capitol Police employee who worked on January 6 of 2021. 1 month before and after January 6th of 2021. Request documents of all bank transactions for each Capitol Police officer who worked on January 6th, 2021. 1 month before and after January 6th of 2021. Questions to ask Nancy Pelosi. Why did you talk to Ray Epps more than 10 times before January 6th of 2021? There's a record of your phone and your contacts with Ray Epps. Did you pay Ray Epps to be at the Capitol? Did you request any friends or work associates to be at the Capitol stationed outside the Capitol? Did you request the Capitol Police Chief to open the Capitol doors? Why did you not obey a request from President Trump to contact the National Guard to be stationed at the Capitol on January 6th of 2021? Check every phone call made by Nancy Pelosi 1 month before and 1 month after January 6th of 2021. Check every bank record of Nancy Pelosi 1 month before and 1 month after January 6th of 2021. Questions to ask Mr. Ray Epps. Who requested you to be at the Capitol on January 6th of 2021? Who paid you to be at the Capitol on January 6th of 2021? Did you talk to Nancy Pelosi 10 plus times before January 6th of 2021? Did you talk to any FBI agents 1 month before, during, or 1 month after January 6th of 2021? Are you an FBI informant? Did you come to the Capitol at Nancy Pelosi's request? Questions to ask the top 5 Capitol Police officers who worked on January 6th of 2021. Number one, who shot and killed Ashley Babbitt? Was Ashley Babbitt armed with a gun or a knife? How can an unarmed woman cause a mortal threat to a Capitol Police officer? Did you talk to Nancy Pelosi before, during, or after January 6th of 2021? Did you have a phone call with Nancy Pelosi regarding opening the Capitol doors? And what exactly did she request regarding your duties on January 6th of 2021? Facts to consider. Nancy Pelosi is paid by the U.S. government. Number 2, Capitol Police are paid by the U.S. government. Number 3, FBI agents outside the Capitol are paid by the U.S. government. And Ray Epps was paid. There are 400 plus Americans in jail and prison because of the direct actions and words of Ray Epps. He said, quote, "We're going into the Capitol more than 50 times before 3,000 people on January 5th and January 6th. Nancy Pelosi, the Capitol Police, both were involved in unlocking the Capitol doors from the inside. And FBI agents fomenting unrest and informants directing directly caused disorder at the Capitol. Americans were deceived, vehemently persuaded, and coerced to enter the Capitol on January 6 of 2021. Individuals are innocent until proven guilty in a court of law. There is direct evidence of collusion to purposely entrap Americans in the Capitol on January 6 of 2021, based upon words spoken by Mr. Ray Epps to 3,000 individuals outside the Capitol on both January 5th and January 6th of 2021. Incontrovertible evidence cannot be denied nor overlooked by anyone. In conclusion, entrapment occurred. If you look up code 645 and 648, that will define entrapment. Every January 6er has a right to appeal their verdict. Every January 6er is innocent until proven guilty. Every January 6er after their appeal can be released. Compensation of $200 per day for each January 6er for every day in detention and jail until released. 645 entrapment elements. Entrapment is complete defense in a criminal charge on the theory that government agents may not originate criminal design, implant in an innocent person's mind the disposition to commit a criminal act, and then induce commission of the crime so that the government may prosecute. Jacobson versus United States 503 U.S. 548, 1992. A valid entrapment defense has two related elements: government inducement of a crime, and number two, the defendant's lack of predisposition to engage in a criminal conduct. Matthews versus United States 485 U.S. 5863, 1988. Of the two elements, predisposition is by far the more important. Inducement is the threshold issue of entrapment defense. Mere solicitation to commit a crime is not inducement. Sorrells versus United States, 1932. Nor does the government's use of artifice, stratagem, or pretense or deceit establish inducement. Rather, inducement requires a showing of at least persuasion or mild coercion. United States versus Nations in 1985. Pleas based on need, sympathy, and friendship. Extraordinary promises of the sort that would blind the ordinary person to his legal duties. United States versus Evans, 1991. 648 entrapment. Outrageous government conduct. While the essence of entrapment defense is the defendant's lack of predisposition to commit the offense, the defense of outrageous government conduct presupposes predisposition, but seeks dismissal of the indictment on the ground that the conduct of law enforcement agents was so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. United States versus Russell, 411, 1973. Thus, the outrageous government conduct defense is not really a defense at all. Rather, it is a claim that the institution of the prosecution suffers from the purely legal defect. As such, the claim is waived unless raised prior trial under Federal Criminal Code 12B1 and B2. United States versus Henderson in 1993. The Supreme Court has never held that the government's mere use of undercover agents or informants or the use of deception by them gives rise to due process violation. Although in Russell it left open the possibility. The requisite level of outrageousness could be reached only where government conduct is so fundamentally unfair as to be shocking to the universal sense of justice. No court of appeals has held that the predisposed defendant may establish a due process violation simply because he purportedly was induced to commit the crime by the undercover agent or informant. Deprivation of rights under color of law. Section 242, Title 18 makes it a crime for a person acting under color of law to willfully deprive a person of a right or privilege protected by the Constitution or the laws of the United States. Section 242, Title 18, deprivation of rights under color of law. What does under color of law mean? Criminal acts under color of law include acts within and beyond the bounds and limits of lawful authority. What is assault under color of authority? California Penal Code 149 PC states that every public officer who under color of authority without lawful necessity assaults, beats any person is guilty of a misdemeanor. A person starts assaulting someone else. The officer acts in defense of the victim. What does 18 U.S. Code 242 mean? Section 242 of Title 18 makes it a crime for any person acting under color of any law to willfully deprive a person of a right or privilege protected by the Constitution or the laws of the United States. What are your constitutional rights? Constitutional rights are the protections and liberties guaranteed to the people of the U.S. Constitution. Many of these rights are outlined in the Bill of Rights, such as the right to free speech and the right to speedy and public trial. Does unconstitutional mean illegal? Something is illegal if it violates the law, including the Constitution. Something is unconstitutional if it violates the terms and interpretations of the Constitution. What are some examples of civil rights violations? Unreasonable searches and seizures, cruel and unusual punishment, losing a job, being passed over for promotion due to discrimination, abuse by a public official, any discrimination based on a superficial quality or belief. What is innocent until proven guilty called? A presumption of innocence means that any defendant in a criminal trial is assumed to be innocent until they have been proven guilty. As such, a prosecutor is required to prove beyond a reasonable doubt that the person committed the crime if that person is to be convicted. Is innocent until proven guilty a legal right? First, Section 11D guarantees the right of any person charged with an offense to be presumed innocent until proven guilty beyond a reasonable doubt. Second, Section 11D guarantees the process whereby the guilt of any accused will be proved will be fair. What happened to innocent until proven guilty? The concept of innocent until proven guilty means that the suspect, a person accused of a crime, is presumed to be innocent until he or she has been found guilty of a crime by a court with appropriate jurisdiction. The prosecution must prove beyond a reasonable doubt that the suspect did in fact break